Good evening and happy Banned Books Week from the Authors Guild and the Authors Guild Foundation. One of the things that the Authors Guild Foundation does is advocate for the rights to free speech. So this is a very important cause for us. Thanks to everyone in the audience for being here and to those of you who submitted a question in advance. We'll have some time at the end of the hour for a Q&A, so feel free to use the Q&A box here in Zoom to add more questions or to chat with each other. With us tonight is Heather Fleming, founder and director of the Missouri Equity Education Partnership, and the author of the book My Black Friend Says, Lessons in Equity, Inclusion, and Cultural Competency. Later, Heather's going to talk to us about myths and misinformation that exist around book bans and some talking points that we should all know. But first, to give us the lay of the land on the legal issues at play with book bans is the Authors Guild's General Counsel, Cheryl Davis. Cheryl, I'll turn it to you.
Thank you, Johnny. And hello, and thanks to everyone for joining us tonight. Just a brief word on the Authors Guild, which is a national nonprofit association of 14,000 professional published writers of all genres. We're the oldest and largest professional writers organization in the US. The Guild counts historians, biographers, academicians, journalists, and other writers of fiction and nonfiction as our members. We work to promote the rights and professional interests of authors in various areas, including copyright, freedom of expression, fair contracts, and artificial intelligence. And as Johnny said, we are currently gathered here for Banned Books Week. And unfortunately, Banned Books Week is year-round these days. As the American Library Association recently announced, a record number of 3,923 unique titles have been challenged between January 1st and August 31st of this year. While that number doesn't necessarily reflect 3,923 separate authors, since there are authors who've had more than one book challenged, it also does not reflect all of the authors who've been affected by these efforts, not by a long shot. Now, new legislation out there is putting increased pressure on authors and their books. While individually filed book challenges obviously affect authors, not only have the number of challenges grown, as the ALA has shown, they've been turbocharged, and they're no longer truly individual challenges. Groups are circulating lists of books to be challenged. This makes it easier for individuals to challenge hundreds of books at a time, many of which they've not read. They're relying on information or misinformation that they've received or that they simply perceive. For example, a challenger for Amanda Gorman's book, The Hill We Climb, as you may recall that she read that poem at the Biden inauguration, stated that the author of Amanda Gorman's book was Oprah Winfrey, and accused the book of having indirect hate messages. And it mentioned certain pages on which there were obviously nothing of the kind. The Washington Post found that the majority of the 1,000 plus book challenges that they analyzed were filed by just 11 people. The Tampa Bay Times reported that around 600 complaints made in 2 counties came from 2 people. This means that a relatively small number of folks have an outsized impact on what books can be on a school library's shelves. Unless a library is simply going to remove the books outright, to which we would object, these book challenges will entail a review process which will take time and library staff hours and may, in some instances, be subject to higher levels of legal review. These reviews are paid for by the school system, many of which are already underfunded. So this means that a relatively few number of challengers can end up costing a school district a lot of money, since a school district that dares to buy books on more controversial topics or that have been challenged in other districts may therefore run a risk of increasing their costs in terms of review. Mind you, this is in addition to the time and costs already incurred as part of the initial book selection process that librarians already do. And this is a misperception out there, is that books just somehow magically appear or librarians just purchase books off the tops of their heads. There are extensive processes that school librarians must go through and review processes they must go through in order to determine what sorts of books are available or are age appropriate for certain groups of students. So they're already doing that. So these laws that are out there creating additional burdens really are trying to solve a problem that doesn't exist. Now, under Florida law, people can appeal a school board's decision on a challenge book to a state magistrate, which might make it easier for the folks both for and against removing books. In Pinellas County, the decision to remove Toni Morrison's The Bluest Eye, however, was made without following the school board's own formal policy. And that's a big problem here because, as we've noticed, when we work with the National Coalition Against Censorship to send out letters to school districts that are removing books from their shelves, often these school districts aren't even following their own procedure, which is a major legal flaw here. Now, it needs to be stated that the impact on authors of these book banning measures is not limited to schools and school libraries. Bookstores and people who sell books to schools and students can also be impacted by some of this new legislation that has been passed or that is simply currently pending in local congresses and legislatures. And the law is only one of the weapons that can be used against this surge in book bans, but it can be a powerful one. For example, in last year in Virginia Beach, a petitioner who was himself running for public office asked the court to find the books Genderqueer and A Court of Mist and Fury obscene for unrestricted viewing by minors, which is not even a legal standard. Now, one of the advanced questions we received here was about the impact of quote unquote cancel culture on an increase in book bans. What I would say is that the election of Virginia Governor Glenn Youngkin, who campaigned a great deal on education reform and banning things like quote unquote CRT from schools, has shown a particular political sector that this is a way not only to get media attention, but possibly to become elected. So this Virginia Beach petitioner and aspiring politician intended to use that case as a template, saying, quote, "We are in a major fight. Suits like this can be filed all over Virginia. There are dozens of books, hundreds of schools." So as you can see, that Virginia Beach case was of vital importance in terms of setting the record straight and the legislature straight. The authors of those two books and their publishers, along with Barnes and Noble, which just happened to be where the petitioner bought the books in question, opposed this petition. And the Authors Guild and other organizations filed an amicus curiae, or friend of the court brief, encouraging the court to consider the impact of this law, not only on the specific authors and specific bookstore at issue, but on other authors, bookstores, and other members of the public and publishing industry in general. Fortunately, the circuit court found that A Court of Mist and Fury and Genderqueer were not obscene, and that the Virginia law that was being used to ban the books from the bookstores and libraries was unconstitutional. However, that doesn't mean that similar efforts still won't be made in other jurisdictions. Some recent legislation in Arkansas would bar an author's books from being made accessible to minors, which is already an ambiguous term since it covers 7-year-olds to 17-year-olds. In June, the Authors Guild, together with the Central Arkansas Library System, 5 residents of Little Rock, and a coalition of other organizations, including the Association of American Publishers, brought a lawsuit in the District Court of Arkansas, asking the court to declare portions of that law unconstitutional for violating plaintiffs' rights to disseminate, receive, and read constitutionally protected books and other media. One section of this law actually imposes criminal penalties on librarians, booksellers, and others for providing minors with materials considered, quote unquote, harmful to minors. And I want to stress that a number of these laws refer to language such as harmful to minors. However, there are laws that that generally do prohibit doing things that are harmful to minors. There are laws that prohibit giving minors access to pornography. However, these laws here that have to do with making books available to minors are just so vague and broad and overreaching that, again, they're trying to solve a problem that doesn't exist. The Arkansas District Court denied the state's motion to dismiss the case and preliminarily enjoined the enforcement of that law. In a detailed decision which discussed the history of libraries and their importance to the American culture, which was an early indication of which way the legal wind was blowing for this court, the court granted the plaintiff's request for a preliminary injunction. The court looked to the potential harm the bill might cause older minors and adults, recognizing that if the law restricted access to books with sexual content for all minors under 18, this could unfairly limit older minors from accessing age-appropriate literature. Moreover, adults who are accompanied by their younger children might also face restricted access to adult-appropriate content in bookstores and libraries, given concerns about minors coming into contact with such material. Essentially, if you're going to force a library or a bookstore to, quote unquote, segregate adult material, that what the court was saying is that an adult then could not take their say 7 or 8-year-old into that section of the bookstore, because then the minor would have access to those works. The Arkansas law, like other similar laws designed to limit access to books, is vague and ambiguous. And as the court recognized, quote, the lack of clarity seems to have been by design. After all, by keeping the pivotal terms vague, local governing bodies have greater flexibility to assess a given challenge however they please, rather than how the Constitution dictates. There is recent legislation in Texas, the poorly misnamed Reader Act, which would require an author's book to be rated in terms of being, quote, sexually explicit or, quote, sexually relevant, which would bar some of their books from being sold to schools, in addition to putting a target on the authors of those books and their books in other jurisdictions. In July this year, the Authors Guild also joined a coalition of Texas bookstores, national booksellers, authors, and publishers. And I want to highlight the publishers because one of the questions we received in advance was whether the Guild is working with publishers on this issue. And the answer is yes, we are. We've joined this coalition to challenge the law in Texas. These ratings must follow vague labels dictated by the state with no recourse for judicial review. The definitions of sexually explicit material and sexually relevant material are particularly problematic since they're unclear and they have no basis in existing law. Essentially, what these legislators do is they cherry pick from different sections of different laws, but they don't create a whole law that makes sense. They neglect to include some modifying language from the pre-existing law. Moreover, the Texas law represents a significant departure from the traditional rights of local communities to determine the appropriateness of materials for their schools. Essentially, this is saying that you need authors and booksellers needed to rate their books for the whole of the state of Texas, as opposed to what books would be appropriate in Austin, what books would be appropriate in Llano County, what books would be appropriate in Dallas, etc., which is a great difference from the way these laws are usually applied. And under this law, many authors' books would effectively be banned in the significant Texas school market, even when there's nothing remotely obscene or sexualized in them. Since most publishers can't afford to create and sell different versions of books to different markets, these authors would lose sales to the school market throughout the country, a market that authors of children's books, young adult books, and literary classics rely on. Moreover, the vagueness of the Texas standard makes it virtually impossible for an author to comply with these various laws, especially in connection with writing future works. The only way they could comply would be to avoid references to sex or sexuality entirely. This would compel authors who want to sell their books to schools to censor themselves and avoid writing books that address issues many teenagers experience in their lives or communities, such as family, love, and preventing or dealing with pregnancy. It also runs the risk of discouraging publishers from investing in new works, and authors may then, as a result, hesitate to write books that could be subject to such stringent regulation. And the plaintiffs in this case, in the Texas case, issued a statement recognizing the rationale behind the law and how it failed to meet even its stated goals. Quote, there's no question that reading in schools should be guided and age appropriate, but this law does not accomplish that goal. It is inferior to existing constitutional standards because it robs parents, schools, and teachers from across the state of Texas of the right to make decisions for their respective communities and classrooms, instead handing that role to a state entity and private businesses. It is central to the First Amendment that the government can restrain or can neither restrain nor compel speech, but this law will force booksellers to label constitutionally protected works of literature and nonfiction with highly subjective and stigmatizing ratings, effectively forcing private actors to convey and act upon the government's views even when they disagree. One of the arguments that we made in this case was that the government was violating First Amendment rights by compelling speech in this case, because you're compelling authors and publishers to issue a certain types of speech which they disagree and that they don't want to make. This law goes against local autonomy, parental choice, diversity of interest, and freedom of expression. Now, as I think I said before, this law was preliminarily enjoined in the state of Texas, and we're going to continue to monitor that situation and see how things go there. A preliminary injunction means that the law, it cannot be temporarily enforced, but the case is still ongoing. The same is the case with the case that happened in Arkansas. And there's legislation all over the country that would hinder authors from selling, displaying, marketing their books in spaces where a minor might have access to them. And we work with the Media Coalition and other great groups following the progress of various bills, and we will continue to challenge these books where we can. Now, one of the legal arguments you see in First Amendment cases is that certain laws are so vague or overbroad that they create what's called a chilling effect, meaning that individuals or groups refrain from engaging in a form of expression out of fear of violating a law or regulation. For example, Florida school librarians are being advised to, quote, err on the side of caution when selecting books. This means that when there is even a question of controversy or the slightest potential for challenge, a library is unlikely to purchase a book. And untold numbers of books and authors will now not even be considered for school libraries. Some authors have told us they've noticed a difference from their publishers in terms of a heightened level of caution for their future books. And this chilling effect is a bipartisan issue. One of our member authors reported that some of his contracts were canceled because his identity differed from those of the characters he was writing about. And this chilling effect also had an impact on the case in Texas, in which the rating system was supposed to take effect in next year, in April of 2024, but the law itself was supposed to take effect as of September 1st. So there were school districts saying, we don't know what to do. We don't know what books to buy. Therefore, we're not going to buy any right now. We're going to wait. And that fear of falling afoul of that law gave an additional impulse behind the court granting our preliminary injunction motion. These bans also have an outsized impact on LGBTQ plus and BIPOC authors. And according to the analysis of the Washington Post, 42% of the challenge books they reviewed had LGBTQ plus authors or themes. 28% have characters of color or deal with race. Amanda Gorman made a statement about the challenge to her book in Florida. And let's be clear, most of the forbidden works are by authors who have struggled for generations to get on the bookshelves. It is also especially sad that students and young readers will be even less able to find stories about their lives and experiences on bookshelves. When we at the Authors Guild talked to Jonathan Evison last year, in last year's Banned Books Week webinar, in his book Lawn Boy, there's an irony in that his character asks, where are the books about me? As I said, the Arkansas court in their preliminary injunctions mentioned that the lack of clarity seems to have been by design. I'd like to paraphrase and say that the absence of these voices seems to have been by design. Now, the increase in book bans and censorship is being fought not just in the courts, but in the court of public opinion. Former President Obama has seen the need to speak out in an open letter in support of libraries and librarians. President Biden expressed a need to act by announcing the appointment of an anti-book ban coordinator, and the Guild has written in support of this appointment and offered to help in that process. As I said before, we've worked with years with the National Coalition Against Censorship, and more recently with Unite Against Book Bans to speak out against censorship efforts. So in addition to bringing lawsuits, there's also advocacy, and this is what another one of the ways in which the Authors Guild is fighting these efforts. We've signed on to 17 letters to school districts this past year alone, often simply asking them to abide by their own policies before removing books from shelves. We've also spoken out against the defunding of libraries, which occurred in Michigan and was threatened in Llano County, Texas. There is a case in Llano County in which the court had instructed the books there were certain books removed from the library system in Llano County. The court instructed the books to be restored. And then the school board of Llano County then announced that they were going to have a meeting to discuss whether they should actually close the library rather than put the books back on the shelves. Fortunately, the decision was made due to a fair amount of outward not to close the Llano County Library. The Authors Guild also supports and amplifies authors like Nora Roberts when she spoke out on CNN against the removal of her books from school libraries. And she said, I say, why does one parent have the right to push their opinion and their feelings on all the parents in the school district? Isn't that un-American? What's that about liberty? One person said these books are inappropriate, and so they're gone from the shelves in the school library. The librarian who was trained and educated and curated the books didn't say that. One person and one person alone usurps the rights of the rest of the parents and takes that access away from the high schoolers. This is the tyranny of the few over the many, and that's just not American. Reading and books open windows and doors to other worlds, other points of view, other experiences. Isn't that what we want in our educational system? Don't we want books to kids to read for fun so they become readers and broaden their outlook? Now, relatively few of the authors of books have been challenged and removed, have the opportunity to go on CNN and argue on behalf of their work. However, there are other ways in which they can fight back. And at that point, I'm going to hand it over to Heather.
Thank you, Cheryl, so much. I appreciate the time to be here and to speak with each of you. So thank you so much to the Authors Guild for partnering with my organization, the Missouri Equity Education Partnership, to address this important issue, as well as Cheryl Davis for providing her expertise and knowledge as we forge a path forward. Many of you are individuals like me, a person at the grassroots level who just wants to do what's best for our community, my schools, and most importantly, my children's future. We are often inundated with information as well as disinformation to the point of confusion about what we need to do next in order to mount an effective fight. That's why I am so appreciative of organizations like the Authors Guild and all of the truly caring people there who work tirelessly to provide us with true information as well as effective strategies for using our voice to make a difference. I am also very thankful for the United Against Book Bans campaign, through which I met Cheryl and through which this is possible. I'd like to stress this one fact. You can make a difference. You may think your voice is too small, but I love this particular analogy by the 14th Dalai Lama. If you think you are too small to make a difference, try sleeping with a mosquito. It always matters to stand up, to make allies with teachers and librarians, and to send proactive support they can use as evidence when challenges arise. Cheryl has aptly provided you with excellent information on what the law says. My job tonight is to help you respond to the misinformation often perpetuated by those who want to ban books. I will just give you a few talking points to help in crafting your messaging and dispelling the myths around this topic. I have asked Cheryl to add her knowledge to any of the talking points that I bring forth. First, we are told that books are not really being banned or that it's a hoax. This, of course, is untrue. So use data. Use data that is clear, that is real, and that is documented. As Cheryl made mention of, the ALA is a wonderful source of information and data, as well as PEN America and other organizations, including the Unite Against Book Ban Coalition, of which we are a part. Another point, these books are pornography, or they're inappropriate, or they're sexualizing children. Please be prepared for that particular argument. That is the first one that they make. Read the books first. Get comfortable with making counterpoints. Have a definition of pornography on hand, which I'll tell you in just a minute, and encourage them to provide context. So what happens on the next page? For instance, genderqueer. They often point to two specific pages that offer explicit content. However, ask them to turn the page, because on the following page is a wonderful conversation about consent, as well as the decision to not go forward. So one of the examples of the definition of pornography to provide is works which have no serious literary, artistic, political, or scientific value, and which portray graphic sexual content for its own sake. This is the Miller test of whether they have a place in the library.
Heather, I just wanted to point out that one of the problems of some of these legislations is that they use the language, but they don't use the Miller test lap standard. They
Yes.
talk about pornography, they talk about there's other things, but they neglect to state that these things have no literary, artistic, political, or social value.
Exactly. And I often provide this particular definition: sexual content designed to excite and which doesn't have a literary value. And I can tell you that if anyone is reading the scene that they point to in The Bluest Eye, and they think that that was designed to excite, then there are other issues that we need to be dealing with. There is literary value in The Bluest Eye, and that particular scene adds to the overall message of the book. The other thing is that what Cheryl said earlier is very true. We have a lot of children, a lot of students who must be able to see themselves and their experiences in books. And unfortunately, not all of our children are able to see positive things in their lives. And so books are ways in which we can have conversations with them about how they deal with these particularly difficult situations. And at times, because it does help students to be able to identify themselves in their particular situation, it also helps them to identify the best decision for handling that particular situation. The other thing to point out about these particular books is that parents have always had a way to opt out. And so one parent's choice should not be able to dictate everyone's. I, again, often say I support any parent's right to make decisions for their children, but they cannot make decisions for my children. I retain that right for myself. Another myth: book bans are good for sales. Cheryl covered this, but I really want to stress this. No, for many authors, they are very harmful, particularly if they are books that are going to the schools and large districts are purchasing those books. Without that revenue, artists, they may get additional book sales from Barnes and Noble, etc., but their book sales will go down, and people won't have access to them as readily as might be necessary and might be appropriate.
They may also discourage publishers from publishing future works by that author.
Exactly.
So it may have a negative impact on the author's career.
So, the other thing, yes, there are big authors who will be just fine despite that. But other smaller authors, I'm an author, and I don't make huge amounts of money from the sales of my books. And so therefore, hey, it being banned, it might get me a few sales, but in the end, it would have an overall harmful effect on me as a small book author. Another one: book bans only impact conservative districts and states, or the idea that this will never happen in my district. This is not correct. It is happening all over. It is happening in blue states and in red states. It is happening in large districts and in small districts. And so point to the data, point to the information that's available so that you can find out exactly where book bans are happening and how to fight them. Another one, and Cheryl again addressed this, but I want to stress it again: all kinds of books are being banned. Again, this is not true. Primarily books by BIPOC authors, which is, Black, Indigenous, and people of color, and the LGBTQ books are being banned the most. And that we are way overrepresented as far as the authors whose books are being attacked. Another one: history repeats itself, and this will all calm down eventually. Well, we don't want history to repeat itself. Because every time books are banned, it connects to a larger movement that causes harm to populations of individuals. So we don't want history to repeat itself. These attacks are interconnected with other issues, and real damage is being done, even if the attention to book bans moves on. So we need to fight it now. And then finally, why should students care? Because they can access this information elsewhere. That is coming from a very privileged position. A lot of us do have access via other sources, but there are some students who do not. And we want children and students to be able to have access to important life information when they have the benefit of supportive adults around. And wouldn't we rather some of these issues be first encountered through literature rather than in real life? My answer to that is yes. I would rather my daughter be able to read about highly complex issues, difficult situations, and be able to process that with supportive and responsible adults rather than encountering it in real life and not being able, not having the skills or the knowledge to deal with it well. And so I will turn it back over to Cheryl. Thank you.
Thank you, Heather. Johnny, I think we had some questions.
Oh, sorry. 1 second. Thank you. Yes. I noticed when you were talking about the bluest eye, about the book being designed to excite, reminded me of growing up in Plano, Texas, where the school dress code said that you couldn't dress provocatively, which put teachers in the position of declaring a teenage child provocative, which is just not a smart way to write a law. In any case, so someone asked how many states have book ban laws passed already. I'm not sure if they mean banning books or preventing books, as it happened in some states, but maybe we don't have the numbers right in front of us, but how widespread would you say the issue is?
It is extremely widespread. And there are, as Heather was saying, it's not just the red states, but also the blue states. And there are also just the breadth of the types of laws. For example, there is a law proposed in the Midwest, I forget exactly which state, that would bar having pictures of any nudity or whatever on a cover of a book, including those sold at a museum. So essentially, you cannot have like a picture of the statue of David on a book cover at a museum. These these laws are just so vastly overbroad. And I think a lot of these, fortunately, we're involved in the Media Coalition, which when these laws come up, they file memos and they draw attention to how many of them are in fact unconstitutional. So a number of them do get knocked out before getting to a certain point. But there are those that still get passed, and that's what we must fight against, like we did in Arkansas and in Texas and Virginia Beach. The law that the petitioner brought the case on was something that had been around since I think the 19 teens, and the court just hadn't looked at it again in decades and realized, oh, this is actually unconstitutional, isn't it?
Wow. Yes, I would say we also have to look at the subtle things that are happening. For instance, here in Missouri, there was an amendment that was passed to a larger omnibus bill. It was called the Bratton Amendment. And although it was supposed to have no teeth really to it, it was still an opportunity for districts who were in line with book bans, or even districts who didn't want to take the chance of going against the law because it was so vague, from it encouraged them to pull books from the shelves. And so the intent, of course, was to ban specific types of books. But for instance, one school district here in the St. Louis area, they ended up pulling the works of Degas and you know, all of these various Van Gogh and all of these various authors who, artists who might have some nudity in their artwork, etc. We can look at the state of Florida, where a superintendent was fired from her school district because she allowed her students to view pictures of the statue of David. And so even if, and I see another comment about the word ban being scary, even I think we need to state this, because even if they do not specifically say ban or it limit access, many times it essentially functions as a ban. And that's where the problem comes in. So we need to state not what the intent is, but what the impact is. And in Missouri, the Bratton Amendment, the impact was that books were banned.
And I just wanted to mention in Oklahoma, in which they were barring teaching of quote unquote CRT, somebody actually asked the schools, just think the director of Board of Education, I think it was his title, essentially, how do you teach about the Tulsa Race Massacre without mentioning race? And he kind of fumbled a bit and said, well, of course you need to teach about this, but I wouldn't tell any children that anything was based upon the color of their skin. Like, it's essentially they wind themselves into knots trying to figure out how to get around their own laws. And it just doesn't make sense if you sit down and you think about something more clearly. And I think the comment that you were referring to, Heather, was somebody saying that shouldn't legislators or school boards or parents, for that matter, be able to determine what reading material is appropriate for children? Nobody's saying, absolutely nobody's saying that they should not be determining this. What we're saying is that they should be applying reasonable standards for doing it and not overreaching it. They should be acting in a constitutional manner. And that's what our challenge is that these laws that people are abiding by are unconstitutional. They violate the First Amendment.
Exactly.
Now in Texas, we had a Texas bookstore owner write in, say, we don't sell to schools. We're an adult-oriented bookstore, not a children's bookstore. But minors come in. So where does that stand in Texas? If that law is in effect, would a bookstore like that be required to rate materials, card customers, anything like that?
Right now, no, nobody has to do anything like that because there's a preliminary injunction. But I know that booksellers and bookstores were plaintiffs in the action, so I believe they would have been impacted as well. And I cannot unfortunately answer off the top of my head what the specific impact would be, but I think probably would have had to been segregation of some kind. But again, I would have to really look at the statute and those arguments with relate to booksellers.
A bookseller that I spoke to in Texas discussed the aspect of even like the undue burden of having to hire people to go through each book in their store, read all of the books, rate all of the books, label all of the books, etc. And so that was part of the basis also of that lawsuit, was that there were also financial costs that were an undue burden to small booksellers and bookstores.
And another one of the unreasonable elements is they had to go back in time to refer to not just books that you're selling currently, but books that you had sold that were still being used by the school system, which a lot of booksellers just aren't even aware of. But they would have to go back in time and on a website list like these books that we sold X years ago, they're still being used, are rated this way.
How can individuals or organizations make use of the law in defending against book challenges?
One of the ways is, as I said before, sometimes these school districts and groups aren't even abiding by their own policies and procedures. So I would suggest that if books are being removed from shelves, that you go back and look at what is the rationale for removing the book from the shelf, and have they complied with their own processes. For example, some people are simply removing books from shelves based upon a challenge, even though their policies provide that there has to be a review process before the book is removed, even temporarily. So if that's the case, then yes, you can certainly draw the people's attention to you're not even complying with your own regulations and policies. Right. So that is one way in the law which law can be used, and essentially we argue against First Amendment rights being violated. If you're a student who doesn't have access to certain books, you may have grounds for a First Amendment claim if you're being prevented from getting access to certain forms of information.
I think it's important, like someone like me at the grassroots level, it's also important to connect with those organizations that you know will fight
Mhm.
these and utilize any reporting mechanisms that you can. So here in the state of Missouri, of course, we worked with the ACLU um, in Wentzville, and parents that were directly impacted by the initial book ban that Wentzville put into place against the Bluest Eye, parents and students sued over that. And so ACLU attorneys were there to help with navigating that, with also gathering information and facts for parents who maybe don't know the law or don't have access to attorneys, don't have the money, funding, etc., to be able to pay attorneys. And so also do that. Please connect with organizations within your state that are concerned about book bans and working on this. Here in Missouri, we have several different coalitions that we worked with. Cheryl and I work with the United Against Book Bans coalition. And in the end, even if we don't have the resources available, we may be able to connect you with somebody who does.
And that's actually one of the reasons behind the United Against Book Ban is individuals can join, and they should join. So people can you can tell people this is what's going on in my community, and they may be able to reach out to you and help you. There's also toolkits available. The Authors Guild has a set of toolkits. The United Against Book Ban does, as Penn does, ALE. There are a variety of toolkits out there so that you can write to legislators. If you realize that there's a bill pending that may affect you, you can write in opposition to it. You can write in opposition to policies that threaten to defund libraries. You can write. You have a voice,
You
and
do.
you should use it.
Absolutely.
Are there preventive measures someone can take, such as like getting on a library board, Friends of the Library organization?
Absolutely. Getting on the library board, we need people, reasonable people, to run for school board. I know that it's tense right now. Some districts where you're like, I don't want to touch that with a 10-foot pole, but we are seeing the results of when extremists that include people who want to openly ban books. That same school district that I've mentioned a few times, Wentzville, we actually just had a sunshine request come through. A concerned citizen filed a sunshine request for emails, and one of the board members had sent an email basically outlining how they plan to destroy the district from within, and they called it Saving Our Democracy. School boards are supposed to be nonpartisan, and it is literally supposed to be about what is best for students. But they want to ignore all of the things that are like, this is best practices for our students. This is what our educators, our administrators have researched, have studied, and what they deem is best. They want to get rid of all of that for their ideological pursuit and their ideological agenda. And in the end, so we need people to run for school boards. Yes, please get on library boards. Be outspoken. Tune into, like in Missouri, my organization, we are in our capital during each legislative session. We put out reminders and information to people about, hey, here are hearings that are coming up. Here's where you need to submit your written testimony. We need people to come to Jeff City to use their voices and to speak out. I think that is really, really important for you to remember. Again, your voice matters. So use that voice. Run for county council, because we also have people, and it's at the local level where these decisions need to be made, and it's at the local level where we need the reasonable people in the room. So there's a lot of things that you can do as a preventative measure, and that includes get involved and volunteer with organizations like mine. We're a small organization. We depend on volunteers, and in the end, we need all hands on deck so that we can prevent this.
There's one additional way in which, yes, of course, you should run for office, but if that's not your taste, there are people who the school boards need people to review these books because there are so many books being challenged and the things get so slowed down. There are some opportunities for people to volunteer to review books. And as Heather put it, we need people, sensible people, who don't just look at it and say, oh my God, they used a bad word, let's ban this book. We need people to actually be willing to volunteer to review these books and help out the school district in that way.
Someone commented if they want to ban sexual content, they're going to have to ban the Bible. Indeed, that has happened in a few places. And someone else asked, is there value in using these procedures to challenge books not intended to be caught in the net, like the Bible and our books? In other words, agitation to show the insanity of it all, that the system is not sustainable. Do we think it's worthwhile to challenge books, as a show of protest?
I will tell you, in all honesty, that really, really amuses me as a tactic, and I love the irony of it. But I don't know in the long term how effective that is as a protest. But yes, I think by all means, drawing attention to the absurdity of the argument, I think is a valid tactic. Yes.
Maybe speaking at a meeting.
But if we're against book bans, we need to be against book bans. And that includes because we undermine our own arguments if we then go in and attempt to ban the books that we don't like or the books that we disagree with. We're doing essentially with it. And so it's like that an eye for an eye leaves everyone blind. A book for a book leaves everyone ignorant, and we don't want to do that. So
agreed, but it just calls
it's good to point out the irony.
Yeah.
And it's good to point out the hypocrisy.
Yeah.
But we don't want to actually use their very flawed and awful tactics in order to fight back. We
go high.
Yeah. Well, I don't always go high. I'll admit. But in this particular case, I don't want to use that particular tactic in order to fight what they're doing, because what they're doing is wrong. We can't pay wrong for wrong.
But it does make sense to say, if you say this, then this follows.
But the reality is this. The reality is that argument is not going to work with them. No. They understand the hypocrisy and they don't care. And so what we need to do is that what our argument should be doing really is empowering and activating the people who are against book bans, the people who understand how dangerous this is. That's what we should be doing, and not attempting to change the other side's mind, because at this point it's been proven over and over again, we're not going to change their minds.
That is very true. And what you're saying also is one of the things that we at the Authors Guild believe is that we are truly stronger together. And that's one of the things behind Beyond Unite Against Book Bans and all of these other groups, because one of the problems with turbocharging the bans is that the quote unquote other side has essentially turbocharged their opposition. Essentially, they circulate lists. Not just do they circulate lists of books that they want to be challenged, as the Washington Post wrote, some of these people are actually Googling these books and looking at them on Amazon and seeing like the algorithm recommends, if you're interested in this, you may be interested in that, and using those gestures to find additional books to challenge. So essentially, against Moms for Liberty, there are other groups out there who are trying to work together and say, and band together and say, like, this is what we believe, this is what we need to fight for, and you need to ideally find your group that you can work with and to fight the fight that you want to fight.
And I think that that's something to really, really stress, is that they're literally circulating lists that say, hey, we don't like this book because of what's on this page, and you need to make this argument when you go to ban the book. They're telling people what to do. In one of the private groups, parents that here in Missouri, there were a group of parents, and one parent even said, I'm not taking time to read all those books. They were challenging books they hadn't even read. They don't know the context. They just know, hey, genderqueer on this page has an explicit picture. If you ask them what's on the next page, they won't be able to tell you.
Mhm.
Or what's the context of that, they won't be able to tell you because they've just received information about where it is, what it is, where it is, and what they should disagree with.
And
So
so I say in some cases it's misinformation
it is.
because yeah, and there's one of the authors we'd spoken to was saying that stories that just report that X books have been challenged can sometimes create their own cycle, their own momentum, because people Google and they say, okay, these books are challenged in that jurisdiction. That means we should challenge them here. And this article says this book was challenged because of X. But if that's a misstatement, if the reporter hasn't looked in to see that the book actually doesn't have profanity or doesn't have sexual activity, but just reports this book was challenged on the basis of sexual activity, then that becomes a self-fulfilling prophecy and people will go and challenge it in other jurisdictions based on misinformation.
Now, about the scope of books being challenged, a few people have asked how much like medical nonfiction informational books are caught up in this.
They also are. We saw here in Missouri, like I said, the Wentzville School District, after the Bratton Amendment went into effect and said, hey, images, sexual images cannot be available, to students. Some of the books that were removed were books about, helping teenage girls to navigate starting their menstrual cycles, to help young boys to understand who their bodies or anything like that. There were books that were removed that I'm sure weren't intended to be removed, but yes, even medical books, like we said, art books that we know have an artistic value and would pass the Miller test. These are books that were also being removed because this law was so vague and so broad that it applied even in unintentional places.
Mhm. That's part of the chilling effect.
Someone asked about the chilling effect. Is there data or information about teachers who have preemptively removed books? I know that there's been images on social media of bare shelves in some places.
There are books have been removed. I don't know what the numbers are on those. There's books have been removed, but people have decided not to purchase books. Books have been taken out of syllabi when they were formerly used as part of teaching. So we know that it is happening. We don't have specific data on that. That is actually one of the things that in the Authors Guild, a recent income survey, we started asking about the impact of book bans. So we're just starting on this now, but in the future, we will be trying to gather up more data about this kind of thing and its impact on authors.
Yes, there have been several like surveys and things sent around to people to try to capture those teachers and individuals who are, self-censoring in order to avoid trouble, but that really is hard data to capture because, even if we do have the mechanisms to ask people about it, how many people are going to take the chance of actually reporting that that's what they're doing? In some, just the reality is in some states and in some school districts, they wouldn't feel safe to do that. Because of threats to their jobs. And let's just be real. We saw here in one of our school districts in Missouri, the Rockwood School District, where two of our African-American district level administrators it ended up leaving the district, but prior to leaving the district, they and the superintendent had to have security, both at their homes and at their offices because of threats of violence. And so, these are dangerous circumstances, and we have school districts all over the country where people feel the same way.
Even just on social media, I see comments that school librarians are making and fighting for free speech and the value of these books. And commenters just say like child porn, you just want to give porn to kids.
I had to send a cease and desist letter to a individual in the Rockwood School District because When we implemented with my original organization, when I implemented my banned book program, she went around to several Facebook groups and et cetera, and social media, stating that I was a groomer and a pedophile, et cetera, et cetera. And so, yes, this ends up being the first thing that when you're advocating for, hey, people should just have the ability to have access to this as it is age appropriate. You're still accused of being this. And one thing that I also wanted to stress is that another tool that people are using is that they take genderqueer, which is a graphic novel, and they make it seem as if librarians are making this, available to the average kindergartner. And that ends up being the next myth that you really need to dispel. Librarians are making these books available at age appropriate levels. Librarians have rules and guidelines that they themselves follow in order to determine whether or not a piece of literature is appropriate for a certain age group. I myself, as a teacher, we used to go in and have to assign what's called Lexile levels. And Lexile levels had more to do with just, hey, how readable is it? What kind of words do they use? It also had to do with inferential load. It had to do with subject matter. It had to do with maturity. It had to do with all of those things. So there might be books that, yes, the reading level is fourth grade, but we would never make this available to a fourth grader because of the content and some of the subject matter within it. So that is another thing to dispel from people. These books that they're trying to point out and say there's sexual content within it are usually books that are made available to high school students at an age appropriate and reading appropriate level.
I think a lot of people trying to ban these books treat graphic novels as though they're like kiddie comic books, which they're not, and they're never intended to be. But they say, oh, it's a picture, therefore it's got to be available for a 5-year-old. No, that's not the purpose of these books.
You would never find genderqueer in an elementary school library, ever. Never, ever, ever.
There are also people who think graphic novel means it's graphic, like it's sexually graphic. They think it means all of them are that way.
Right.
So there's that. So you mentioned you sent a cease and desist letter. Someone asked, what if authors feel like they're being intimidated, harassed? What action should they take to protect themselves?
Now is the time for all of us to band together, and this is where the volunteerism comes in. One of the things that we did with my organization is to cultivate a list of attorneys within the state who are licensed to practice within the state, who would be willing to send cease and desist letters for free. If we had to take further legal action, of course, we would then arrange a price with them and see if my organization had any funding available to be able to supplement that individual's fight. But we did have that list going. But that's where it's also really important, again, to connect with organizations like the ACLU. We have the Legal Services of Eastern Missouri here. We have all kinds of, anti-censorship organization, civil liberty organizations here that are willing to fight, that are collecting stories. We'll listen to your story and we'll see if within your story or within your story plus another person's story plus another person's story, there is a lawsuit to be filed in order to fight for your rights. And so I would say that's what you can do. There are a lot of concerned attorneys across our states who are not concerned necessarily about the money that comes from it, but who are really concerned about making sure that citizens have rights and that they have the ability to fight back legally, as well as, of course, through their words, through their legislature, through their school districts, through public office, etc.
All right. Well, that is an hour. I think we can put a pin in it here. But Cheryl, if you have final words, please? Otherwise, I was going to say it's Banned Books Week. There's a lot going on, including a lot of in-person events. So you should check out the Banned Books Week site. There are readings and fun things where you can probably connect with people in your area who agree with you on these issues. Cheryl?
Okay, I just wanted to add like a quick roundup in terms of like ways in which authors can fight back. As Heather has already said, you want to take the opportunity to put works in context. We would ask that people speak out, authors speak out with sincerity and clarity. You know best what your work actually says. And some authors have actually attended book school board meetings where their work was challenged. If that's not possible or preferable, you can send and circulate a written statement. One of the authors we spoke to has a file of messages she's received from readers of her books on how her books have helped people. And she sends those to school boards. So somebody literally said, "Your book saved my life." You want to retain copies of those and circulate those to show that your book is speaking to somebody who needs to hear this message. Reaching out to, of course, the Authors Guild and other organizations for assistance. Review your legal options, if any, to these challenges. As I said, we've seen that libraries and school boards sometimes violate their own internal processes, and you can challenge removal of book on those grounds. And please remember, this battle is an ongoing one for the individual authors at issue, for the Guild, for MOIP, and for our country as a whole.
Thank you. Thanks everyone for being here. Thank you, Heather Fleming,
Thank
and
you.
everyone at Missouri Equity for your help with this.
Thank you.